Well, most of the time when a farmer or rancher sells land, it's accounted for as a capital gain. But there can be situations where the gain will be ordinary in nature, particularly when farmland is subdivided or sold into smaller tracts. Joining us now for today's Rural Money segment is Roger McEowen with the Washburn University School of Law. Thanks so much for joining us, Roger. And when land is sold, talk about the difference between a capital gain and an ordinary gain.
Well, good morning, Christina. That's a great question, and this is an important issue for farmers and ranchers that sell land. Most of the time when they sell it, they will qualify that gain for capital gain treatment, and that's good because the capital gain rate is most often going to be lower than if that gain were taxed at ordinary income rates. But the difference between the two, basically the code says that a capital asset is everything that you hold as a taxpayer unless the code says that it's not. And so that's an interesting way that the Congress set that up. But there is one code provision that says that a capital asset does not include property that the taxpayer holds that they're going to sell to customers in the ordinary course of their business. So if it's sold for business purposes, that generates ordinary income that's going to be taxed at higher ordinary income rates. And so that's really the line, and the line depends on the purpose for which the taxpayer was holding the property. So why was the farmer holding that land, and why was it sold?
Okay, well, you're really good about giving us some examples to help us kind of follow you even better. Can you give us an example in this case?
Sure. There's a recent decision out of the tax court. It's called Sugarland Ranch Development case, and it was out of the little area near Houston, Texas. And this was a corporation that bought and developed land for the purpose of turning that land into housing developments and commercial developments. So this is an issue that comes up in agriculture on the rural-urban fringe, where you've got farmland that is also primed for commercial development. And so you've got this business that acquires just shy of 1,000 acres of land. It used to have been a former oil field, so they cleaned it up and they built a levee and they entered into a development contract with the local city, Sugarland, Texas, to set up the rules for developing it. Well, they had done all this work, and then in 2007, 2008, of course, the real estate market went south, so they didn't do anything. And it wasn't until 2012 that they sold any significant part of the land, and they sold two parcels then, about 530 acres, to a home building company. Well, long story short, they report the gain as a capital gain. They weren't. Their argument was we didn't hold it for sale to customers in the ordinary course of our business. We had ceased doing anything with respect to the property for a number of years. We didn't market it. We even adopted an agreement amongst the partners that we were changing the reason that we were holding the property. And the IRS didn't like that. They said, no, you initially acquired it to develop it, and that status stays with you for the length of time that you hold it. And the tax court disagreed with that and said, no, you can convert yourself from a developer to an investor. And that made a big bottom line tax difference because it was capital gain.
Wow. Okay. Well, we really appreciate you bringing those really helpful scenarios that people actually had to go through. It's always great to hear from other people's stories. So we thank you as always. We love talking to you. Roger McEowen with the Washburn University School of Law.